can start without presentation. The topic of my speech is the rule of law and the freedoms and rights of elderly people. As we know, the modern concept of the rule of law has its German origins and its name itself is a translation of the German Rechtsstaat. This term is translated in our Polish language as a state ruled by law. This, how among others, the constitutional legislator, Article 2 of the Constitution, the Republic of Poland is a democratic state ruled by law, or as state of law. Despite different names, state ruled by law, or state of law, Rechtsstaat, rule of law, and rule of law state, are based on the same postulates, and therefore these concepts can be used interchangeably. The concept of the rule of law, German, was developed in a doctrine in the 19th century. German legal theorists increasingly postulated replacing state authority functioning on the basis of the decision-making principles, that is, decisions of the princely authority, with an authority making its decisions based on positivist principles of law. The content elements of the rule of law specified at the time therefore came down to binding the ruler's actions with law and to legal regulation of relations between the citizen and the state. The creator of the concept of the rule of law was, according to some authors, Placidus, who was the first to use this concept in his work in 1798. However, most representatives of legal science indicate that the first author to specify the concept of the rule of law, Rechtsstaat, and introduce this concept to the science of state law was Richard von Moll, who in the work published in 1832 gave a legal characteristic of an anti-absolutist state. According to von Moll, Rechtsstaat is a concept of a state of law understood materially. Opposing the postulate of Immanuel Kant's school to limit the goals of the state only to securing and implementing the law, he tried at the same time to reconcile the subject matter proper to cameralism with the liberal legal and constitutional science, born under the influence of French constitutional doctrine. According to Richard von Moll, a necessary condition for defining a given state as a state of law is to examine whether it considers the principle of citizens' freedom to be paramount. This principle is determined by the goal of every state operating on the basis of law, which is to provide individuals with the possibility of comprehensive development. Only by leaving each member of society a wide sphere of freedom to decide about themselves, limited only by clear regulation settings and boundaries beyond which interference in the sphere of freedom of another person occurs, and recognizing the individual as an entity fully responsible for the path of their self-fulfillment, does the chance of creating a truly civic society arise. However, a citizen should act and move within the state within the limits set by reason and law and the duty of obedience to authority. Richard von Moll left a wide margin for state activity. However, he emphasized that the state should support the achievement of the goals of the individual and society, but only those that require such assistance. The postulate that the state's actions should be based on the principle of subsidiarity, not welfare. The purpose and task that the state should fulfill were decisive for him, while the form of government, monarchy, republic, was definitely secondary. The other creator of the concept of the rule of law, Stahl, unlike Richard von Moll, sees the distinguishing features of the rule of law in the so-called content inhalt of state activity. It was Stahl who was the forerunner of the concept of the formal state of law. According to him, the distinguishing feature of state of law is the method of achieving specific goals and not the goals themselves. Stahl includes the following among the postulates of a formal state of law: the primacy of the Constitution, the direct application of laws by state officials, the separation of the justice system from the administration, and the independence and irremovability of judges. It should be noted here that 19th century and the first half of the 20th century were dominated by the formal understanding of the rule of law. The vast majority of authors adopt such a concept, which is emphasized by contemporary legal theorists and constitutionalists, who often identify the formal concept of the rule of law only with legal positivism. After World War II, supporters of the formal state of law, under the influence of totalitarian states, often changed their views, adopting the material concept of the rule of law. These include, among others, German philosopher Georg Radbruch, who, moving to the position of a material state of law, created the so-called Radbruch formula in order to quickly cleanse German legislation of the Nazi component. Nevertheless, even today, the formal concept is still alive, although consistently and rightly supplemented by material elements. Undoubtedly, despite the differences of the understanding of the concept of Rechtsstaat from the perspective of its precursors, this concept is a denial of systems of government by people with broad, undefinite, and uncontrolled power. It categorically rejects the decisionist political concept and the absolute power. The basic negative postulate that distinguishes the state of law, rule of law, is therefore the exclusion of discretion and arbitrariness in the actions of the authorities. From this point of view, it is identical to the rule of law developed in the Anglo-Saxon countries based on the idea of the rule of law. Therefore, constitutional axiology is a comprehensive understanding of the general clause of the state of law, combining both the formal and material postulates of this concept of the state and law, which is a kind of a rational combination of the state of laws and the state of judges. The analysis of the formal requirements of the Rechtsstaat concept, which are relatively easy to define, and the material requirements, the attempt to catalog which causes more problems because they force us to ultimately opt for a certain system of values, leads to the reflection that the idea of the rule of law should consist of both of these premises, just as the law itself is a combination inseparable of its subjective use and objective lex sides. The rule of law must be analyzed from both the formal and material sides. Ultimately, the Constitutional Tribunal expressed a similar view in its judgment of April 12, 2000, in which it stated, among other things, that, quote, if Article 2 of the Constitution is not to remain just an empty declaration, it is necessary to take into account the generally accepted standards of the rule of law, as well as to consider what shape, model of the rule of law the Polish constitution has adopted. Even the creation of norms, which is impeccable from the point of view of legislative technique, does not exhaust the essence of the rule of law. These norms must implement the basic assumptions underlying the constitutional order in Poland and protect the set of values that the Constitution expresses. Consequently, it is impossible to assess compliance with the principles of the rule of law without taking into account the values indicated in the preamble to the Constitution and eliminating the provisions specified in Article 1 of the Constitution, stating that Poland is the common good of all citizens. All this allows us to conclude that the formal postulates of the rule of law constitute only the construction of such a state. The structure is fulfilled through the implementation of the material premises and the state understood in this way. Only they determine its value, that is, the fact that it is actually a state of law. The analysis of the achievements of the doctrine of constitutional law in Poland in relation to the enormous legacy left by the precursors of the Rechtsstaat concept in Germany allows the formulation of the essential elements and principles of the constitutional principle of the rule of law understood in a comprehensive manner. These principles include the following: 1. Law in force; 2. Legalism; 3. Implementation of formal postulates; and 4. Implementation of material postulates of the concept of the rule of law. Catalogue of formal principles created in the literature on the subject usually showed rather small differences. Undoubtedly, the most important of these postulates include the following: 1. Division of powers; 2. Constitutionalism and its guarantees; 3. Legal certainty, legal security; 4. Prohibition of retroactivity and protection of acquired rights; 5. Proportionality of law; 6. Appropriate vacatio legis; and finally 7. Democracy. The material postulates do not concern the very structure of the state and law, the formal requirements that both the state and law should meet, but the content of this law and the goals of the state. This is therefore about the values which should be reflected in the content of statutory law. Indirectly, it is also about the fundamental goals of the state implemented through the law it creates. 3 basic material postulates of the Rechtsstaat concept can be identified. 1. Reflecting a socially accepted system of values based on natural law in the content of the law. 2. Respecting and protecting fundamental freedoms and human rights. And 3. Implementing the principles of social justice. From the perspective of the topic of this speech, the most important is the second of the material postulates, that is, respecting and protecting fundamental freedoms and human rights, particularly the freedoms and rights of the elderly. This is a fundamental postulate, the implementation of which is an inherent feature, a factor constituting states called states of law. The tasks of the legislator in a state of law in relation to liberty rights are, among others: 1. To indicate the subject of the law; 2. To indicate the obligated entities; and above all, 3. Ensuring the actual conditions for the implementation of freedom, removing the most serious actual obstacles to the implementation of freedom rights. The latter task is particularly important when it comes to the freedoms and rights of elderly people in the face of a rapidly aging society. What is the threat to the freedoms and rights of elderly people? The effect of the exclusion and loneliness of the elderly is a radical limitation or even exclusion of the possibility for this part of the society to exercise the freedoms and rights guaranteed in the Constitution of the Republic of Poland. The following freedoms and rights are at risk the most. 1. Specified in Article 6 of the Constitution the right of access to cultural goods. Quote, the Republic of Poland creates conditions for the dissemination and equal access to cultural goods, which are the source of the identity of the Polish nation, its survival and development. End of quote. Therefore, in a rule of law state, in an aging society, senior policy should include the development of facilities such as senior homes, intergenerational education centers, rural housewife associations, universities of the third age, etc. 2. Specified in Article 67, the right to social security understood comprehensively, sensu largo, not only as the right to a pension. Quote, a citizen has the right to social security in the event of incapacity for work due to illness or disability and after reaching retirement age. The scope and forms of social security are determined by law. End of quote. In this area, the development of social care homes, day care centers for seniors, etc., is particularly important in a rule of law state. In this mode of state, in a rule of law state, cases of elderly people suffering in solitude in apartment blocks without a lift, trapped within their own four walls, should be systematically eliminated. 3. Guaranteed in Article 68 of the Constitution, the right to health protection. Quote, everyone has the right to health protection. Public authorities provide citizens, regardless of their financial situation, with equal access to healthcare services financed from public funds. The conditions and scope of providing benefits are specified by law. Public authorities are obliged to provide special health care to children, pregnant women, disabled persons, and the elderly. End of quote. In this area, a rule of law state with an aging society is obliged to develop geriatric departments in district hospitals, medical care facilities, and rehabilitation centers for seniors. The lack of such facilities, or the insufficient number, causing their inaccessibility, is in fact a violation of the right to health protection of the elderly. And 4. Stated in Article 69 of the Constitution the right to assistance in securing existence. Quote, public authorities shall provide disabled persons in accordance with the Act with assistance in securing existence, training for work and social communication. End of quote. All these provisions of the Constitution, which on the one hand indicate the freedoms and rights of elderly people, are also program norms establishing specific tasks of the state. All these tasks are called comprehensive senior policy. In order to create conditions for the proper and dignified existence for elderly people, the state is obliged to introduce reforms and solutions that, on the one hand, counteract the phenomenon of loneliness and exclusion of elderly people, and on the other hand, allow the rest of the society to benefit from the wisdom and experience of seniors. Therefore, it is definitely necessary to increase efforts aimed at counteracting the exclusion of elderly people from the labor market, as I said, creating universities of the third age, promoting senior volunteering, and creating intergenerational clubs, intergenerational education centers. We also need to place greater emphasis to educating young generations to increase their awareness to the need to respect elderly people and the need to benefit from their wisdom and experience. We also need much better systemic solutions in the health center aimed at preventing and fighting diseases of the elderly. As I said, there should be definitely more geriatric and rehabilitation departments for the elderly. All these activities are activities supporting seniors. However, according to Professor Pikuła, attention should be paid to the following aspect of the problem. Senior policy activities are aimed primarily at seniors who do not struggle with multi-morbidities, live in large urban centers in their own apartments, and have the opportunity to use the goods of technological progress. There still remains the issue of elderly people, sick people in small towns, small villages, left alone with problems and diseases without access to electronic devices. We need to definitely increase our efforts and do our best to help them. All these activities aimed at effectively ensuring that seniors can enjoy their freedoms and rights are a sine qua non condition for defining our country, and every country, with its unfortunately aging society, as a rule of law state. Thank you for your attention.